Welcome everyone to the Judiciary Committee hearing this Thursday, February 15. This is our 9:30 agenda and our only agenda. If we have a technical failure on the Zoom side, we'll try again tomorrow, February 16, in this room 016 at 9:31 a.m. Otherwise, it's just a 2-minute time limit for testimony. If you can stick around after your testimony is over, members often have questions. First up today is SB 2686 relating to the disclosure of personal information of certain public servants. Bills intended to address threats and violence against public officials. First up on 2686 is Laura Miyashiro for the Department of Law Enforcement. Good morning.
Good morning, Chairman. Good morning, Vice Chair Gabbard and members. Laura Miyashiro for the Department of Law Enforcement. We just have comments. The DLE is in strong support of these protections for public servants. We don't have any comments on the substantive provisions of it, just the placement of one of them, which is in Section 4 of the measure. One of them is being placed into Chapter 801G, which is the Address Confidentiality Program. The DLE is, I am currently implementing this program. It is a self-contained program, so any type of other scheme that's going to just come in and be inserted in that chapter will cause confusion, just doesn't belong in there. So we do have a proposed solution, which would be perhaps create 801H or any other letter designation so that that provision can go in there, or perhaps change the title of 801G and name it what the committee feels appropriate, and make a Part 1 Address Confidentiality Program self-contained, and then Part 2 put this provision in. So thank you very much for considering our testimony.
Thank you very much. Next is Leslie Kobata for Department of Land and Natural Resources. Good morning,
Chair, Vice Chair, members of the committee. Les Kobata with the Bureau of Conveyance, and I represent the LNR. Presented our testimony to all of you. Hope you had a chance to review it. We had some comments and some real concerns about the ability to successfully implement this bill. We understand the intent fully. It has a lot of merits. There are things being done in other states as well. And one of the recommendations that we're making is that we might want to pursue more information with one of those states who has successfully implemented a program like this. And I point out Minnesota in particular. I'll be around for questions if there are any.
Great, thanks very much. Next is Cheryl Kazu, Park Director, Office of Information Practices, on Zoom perhaps. Oh no, you're here, I'm sorry. Good morning.
We provided extensive testimony, and we are, in support of the intent to protect judges and other government officials from threats. But we have a lot of concerns about the proposed placement of these provisions in the UIPA, because it would conflict with a lot of existing provisions in the UIPA. For example, the mandatory disclosure requirements to provide, real estate property tax information. Now, understand that this information now is not being provided according to a person's name, but according to the property tax address, the tax map key. But still, we would have lots of conflicts between this bill and not only this mandatory provision, but other provisions of the UIP that would likely create a lot of confusion. And at best would be a serious practical challenge, but at worst, totally unworkable. So I hope that you will consider our testimony, and I'll be available for questions.
Thank you. Next is Mark Tom or Stella Camp, Deputy Attorney General. Good morning.
Good morning, Chair, Vice Chair, members of the committee. I'm Stella Camp, Deputy Attorney General. We've provided testimony with comments about the criminal provisions, particularly lacking definitions in both of the criminal sections, which are in different chapters. We also have concerns about the additional UIPA exception in HRS 92F13. It could be read to exempt pretty much all information that is in government records to the extent that it could possibly be used to endanger a public official. And we'd like to note too that this would affect the list in the UIPA under 92F12. That's the list of information that is presumptively public. So the records in that section are public in their entirety, which includes the home addresses. So information like building permit information, Bureau of Conveyances information, water consumption data, people borrowing funds in a state program, all of that, it's public. And the agencies aren't allowed to redact the information. Currently, with other records that are not on this list that needs to be made public, agencies do redact home addresses, home phone numbers, cell numbers. If we had license plate numbers on any record, we would redact it. But I think the problem that I see is that the information sought to be protected is already available on the list of presumptively public records.
Okay, thank you.
I'll be available if you have any other questions.
Thank you. Next is Thomas Berger, Staff Attorney for the Judiciary. In support, Andrew Kawano, Director for City and County of Honolulu. With comments, Ben Krebs for Public First Law Center. Good morning.
Morning, Chair, Vice Chair, members of the committee. My name is Ben Krebs, and I'm testifying for the Public First Law Center. We support the intent of this measure, but we do oppose it as written. Our main concern is the creation of a new public records exemption. We share a lot of the same concerns as the Attorney General's office, in that as written, it has a significant potential to be applied too broadly. And we'd also note that currently the privacy exemption does cover and protect a lot of the information that is the subject here. And also in our testimony, we link to some federal congressional testimony, and that highlights the role of data brokers in making some of this information available to the public. And these are companies that scrape like mobile devices and credit applications. And that's where, according to some of this testimony, a lot of the bad actors may be getting their hands on this information, not necessarily public records. We offer a few other comments in our testimony, and I'm available for questions.
Great, thank you. Next is Anton Joseph Van Sevener, Counsel on Privacy and Data Policy for Software Information Industry Association on Zoom. Yes, I think. Good morning. Mr. Van Sevener, are you there?
Oh, hi, I'm sorry. I had some connectivity issues. Thank you to the chair. Thank you. Good morning. My name is Anton Van Sevener, and I'm a counsel for privacy and data policy with Software and Information Industry Association, or SIA. We are a trade association representing roughly 375 companies, reflecting the broad landscape of digital content providers. And we must oppose SB 2686 because of potential shortcomings regarding the policy of disclosure, not just public posting of the information included under the bill. We're concerned that a vibrant, free-flowing public domain where people can obtain accurate and timely information is essential to a functioning democracy and enables a variety of important activities. But as drafted, the bill would produce unintended and unworkable policy outcomes. Personal information may not be publicly posted, but it is disclosed pursuant to authorizations in federal law for a number of important reasons, including those that apply to government officials, including fraud prevention, legal compliance, and enforcement of illegal activity, and as part of other more routine efforts such as loans, credit, and other financial transactions. And we're concerned that the approach in SB 2686 is a marked departure from comparable privacy laws and creates implementation challenges because it lacks exemptions for example, legal compliance, fraud prevention, Gramm-Leach-Bliley, HIPAA, DPPA, and FCRA regulated data. So we do agree that public employee safety and protection of privacy is a legitimate legislative priority, but must be balanced against valuable public uses. Thank you.
Thanks very much. Next is Richard Varn, Executive Director for Coalition for Sensible Public Records Access.
Yeah,
Good morning.
Thank you, Mr. Chairman and members, Vice Chair. We would echo most of the comments that have been stated already. We did provide written testimony. We've also provided at the chair's request a more comprehensive and thorough approach, we feel, to how to address the problem of improving public safety for public employees and reducing risk that's based on decades of practice that has worked to reduce risk, but has not properly been focused on protecting the newer venues and the newer risks that are being posed daily to public employees. And we think this issue is deserving of a much more comprehensive approach. At the chairman's request, we did provide that paper that lays that out. If others would like it, we can provide a copy. We would echo the primary points. We think the law, as it's written, is overbroad and vague. We do oppose the idea of criminalizing mere disclosure. We do think that there's a way to write a good law that criminalizes public posting with criminal intent to harm, harass, or otherwise harm someone and put someone in danger. We do note that these things, as a former CIO and a legislator myself, I understand that these things are costly. The redaction efforts that are being asked here to be undertaken by many parts of government would cost money and would, as noted, restrict a lot of everyday transactions that people rely on and restrict the oversight potential for government for people who watch on government and people who watch dogs in the press and individuals. So we would like to see a more clear and consistent one that, as we noted, would be more aligned with other states and other approaches that have been taken that have been proven to be effective. And we would be available in any way to support you in crafting such a law and offer our help. Thank you very much.
Thank you. Next, we have Douglas Miller, Legislative Committee, League of Women Voters of Hawaii, in opposition. Thomas Williams, Executive Director of the Employees Retirement System, in support. Dylan Hoffman, Executive Director for TechNet Southwest, in opposition. Next is Randy Pereira, Executive Director for Hawaii Government Employees Association, in support. Londa Biggs, Director of State Government Affairs for RELX, comments. Ad hoc Committee on Judicial Security, testifying for American Judicature Society.
Good morning, Chair Rule, Vice Chair Gavin, members of the committee. This last week, the American Judicature Society Ad hoc Committee on Judicial and so we stand on written testimony.
Stand on written testimony, which is in support or
we
comments.
Intent, but we think that we have the same concern.
Why don't you come on up? Sorry. So everybody can hear you. Go ahead.
Well, we support the intent.
Okay.
Clearly, we think it's really needed to have protection for public servants who are threatened. And so the real concern is the ones that have been expressed in prior testimony, which is the challenges dealing with implementation and compliance. Just for example, in our written testimony, we reference the federal legislation. Mm-hmm. And the federal legislation basically requires a notice and removal process. I think as some of the prior testifiers have indicated, it's not just a one-time thing where you change the law. What the federal judges experience is that they have to continually monitor data brokers placing new data that comes up onto the websites, and so it's very costly, and time consuming. And so the question is, how do you create a balance, that achieves the goal that this bill is intended to achieve, which to protect public servants, versus the challenges of implementation and compliance.
Thank you very much. Thanks for coming.
And so there was a bill that 2379, which is submitted by the judiciary. We think that addresses a balanced approach.
Okay. All right. Thank you. Next is Lois Crozer, in support. That's everybody who signed up for SB 2686. Does anyone else wish to testify on SB 2686? Seeing none, members, questions? Senator Elefante.
I have
go
a
ahead.
question for Mr. Varn, if he's still online.
I am.
Hi, Mr. Varn. Thank you for your testimony. I don't know if you heard some previous testifiers, but I think from DLNR, they mentioned Minnesota, and from the gentleman who just last spoke, Mr. Ivan Louis Kwan, mentioned a few states, Delaware, Illinois, or New Jersey, as some examples. Do you have any particular examples of states that Hawaii could model as it relates to this legislation?
Minnesota does have a good overall approach to the way they manage information. I think it's worth looking at. I haven't looked at every one of them to make sure it abides by principles that I could support, but I can tell you that the Georgia's also been mentioned because Georgia takes a more broad-based approach to protecting information in general and not just for public employees. And that's being advocated by the National Freedom of Information Council. I know they support that starting point. But I think the starting point is, as I've tried to point out, is that I think the best place to start is looking at the risks, what has been proven to be a proper countermeasure to address those risks, looking at the existing laws, and what can be used from those existing laws to address it. So I think the problem is not so much copying what other states did in this narrow area, but looking more broadly. That would be what I would propose and suggest.
Okay, thank you. Thank you, Chair.
Thanks. Other questions? Bureau of Conveyances, could you come back up, please? So it seems to me like one of the most difficult parts of this is that is the home address, because that unfortunately is where some violence has occurred across the country. The Bureau of Conveyances, I've spent many quality hours in your files years and years ago, but I can't remember what. I know that like if you have a mortgage, that almost certainly identifies the location and the owner, or the mortgagee, or the mortgagor. Sure, the mortgagor. But what is that correct? The home address and the name of the owner is there in your records for everybody basically who owns a house?
No.
No. Okay, good.
So
okay.
yeah, the good news is no, it's not. The not so good news is it's available in a lot of other places besides the Bureau of Conveyance.
Okay.
One place in particular that I'm surprised is not here to speak up on this matter would be the real property tax offices of each county.
Mm-hmm.
That is the easiest one to just put a name in, put an address in, do a reverse. There's a number of ways you can do it, but it's just in plain view with much more information than what the Bureau can offer.
Okay.
So I don't know if it's a concern about the accessibility of that information, because I mean, there are several parts to it. There's information that's already been out there that will be difficult to pull back. There's information going forward that we want to protect, understandably. And then there's literally paper that is very difficult to redact short of whiting out. And so just the practicality of what we're being asked to do in this bill comes into question. And this is where I think there are a lot of stakeholders that would have pretty good input if there were maybe an organized way of gathering that input, the concerns, and seeing if there's a balance. And as the other gentleman spoke to, maybe looking at the risks and what is already existing out there might be the first approach. But I think all of us agree that the need to do this, whether it's for public officials or whoever it is, community of interest, that a logical and a workable, practical plan, should be put in place.
So let me follow up. So is there personal information
Yes.
in the records?
Yes.
But it's not, but you were saying that it's the good news is that you don't, it's hard to find, or what's the good news about
The
that?
Bureau does a really good job of hiding that information. Yes, it's just difficult to find. The information is not indexed in a way that's very simple. To just put a name in, or put an address. A name can be put in, and that is the easiest way to do it at the Bureau. And give or take, depending on the kind of document that we have recorded, it may or may not have actual address information, Because some of our documents get returned to an attorney.
Uh-huh.
So let's say the home address of that individual that might be named in that document may not be there, but there are ways to connect the dots, I guess.
Okay, but and I realize this isn't your system, but on the real property tax side in the counties, you can do it by name. It's not just by TMK.
Actually, it's by TMK, and address is the first cut.
Right.
Yeah, I am
But-
not familiar
but if
that
you-
you can actually put a name in that system.
And then see what you,
Yeah,
okay.
but it's pretty easy, for example, to put in the address of a building
Uh-huh.
and then a general address of a building, and a list of units would come up, and then the information as far as the owners and things would be right there.
Okay.
So it's
So
pretty
I
easy
know-
to do.
I know some jurisdictions, you just put in a name and everything that that person owns in that county pops
Right.
up.
That's the only difference with Hawaii and many other states is there are certain functions that are a state function, and for example, the real property tax falls under a county function. So never the twain shall meet right now. We're hoping that we can, because there's a lot of advantages in being able to do that, but it would further complicate this issue.
Thanks. Senator Garrett, go ahead.
Mr. Putter, you had mentioned earlier in your earlier testimony about Minnesota being a possible model. Have you looked at the other states in comparison, or?
I have not, unfortunately, and the only reason I brought up Minnesota is they have, from a conveyancing standpoint, have a very similar system to us with 2 systems of recording. So we do a lot of communication with them. They brought up a program that they call Safe at Home, and it originated as a protection for battered wives, for that profile of people. And they found that there were so many unintended consequences in the way they were originally going to go about it, that they actually established a state organization that, again, organized everybody, got the stakeholders together, and tried to put something together that was going to be practical and the ability to implement successfully. So it's been going on for a number of years now. And even with that effort, I'll tell you, from my standpoint, where I sit and the similar function in Minnesota, it is not an easy thing to do. It's there are a lot of places that it can still fall apart, but it's still the best effort because it's a coordinated effort.
Thank you, Chair.
Thanks.
So I have a
Okay,
question.
Senator
Okay.
Mitchell, go ahead.
Thank you. So as somebody who drafts documents, I do know, so I'm going to dispute what you said about the no personal information, because it's part of the drafting requirements that a grantor, grantee, or mortgagee is required to have their residential address on the document itself. But I agree with you that it's not as searchable. And I also agree with you that, at least compared to real property tax, because I see Ivan Liu Kwan, I don't know whether or not he did this, but when I do collections, it is easier to search on property tax rather than Bureau of Conveyances, because in Bureau of Conveyances, in order for you to do the search, you have to register.
Yeah.
Or, yeah,
Okay.
now at least.
Yes, you're
A long time ago, you didn't need to register, but now you have to register with a credit card and everything. So I commend you for that. But I want to make sure that when you answered the chair, that it was more accurate in the sense that unless we change the drafting guidelines, the document itself, when you are able to download it, does have residential address on there.
And I do stand corrected, Senator. You're right.
Thank you very much.
Thank you. Thank you very much. Can I have backup, Ms. Laura Mayashiro for DLE? Were you the one that testified on the, you're suggesting that we put it in a different section?
Just that one provision.
Yeah, okay, so
Yes.
can I ask you about the program, the underlying program that I'm now blanking on the name of, the one
The
that's,
address confidentiality
Yeah.
program?
so how do you address the problem that we were just talking about with, if the person whose identity you're trying to protect owns a piece of property somewhere, is that still out there on the real property records?
Okay, the address confidentiality program is not really an identifier. It's more the location of an address. It's a nationwide program. Over 30 states have implemented this. They are limited to survivors of domestic violence, sexual assaults, or stalking. So it's a limited number of people.
Right.
There's a full applications
I
process.
understand that. So,
Okay.
but then how does it work in terms of?
Right, okay, so I'm getting there.
Okay.
So it's a narrow pool of people. They have to apply. If they are, and this is also with mandatory victim services organizations help. Okay, and then they will get a authorization card. They can take it to any state or county office for services, benefits, what have you. And that state or county agency must accept the substitute address that's on the card, which is basically the DLE administration's building. From there, their mail, any correspondence that is postal mailed will go to the substitute address, and then we will forward it. So the purpose of it is so their actual address, and that's residence, school, or employment, will not be in any public records database at all.
Okay, so then how do you take, if the person owns a piece of real property?
Okay.
How do you take that out of the real property system?
Well, it wouldn't even be in there because they would have their substitute address in there. There also are some exceptions as to, like for education, you know, I'm sorry, I can't, I have to go look that up specifically, but they're going to have a substitute address for everything. If, for things like taxes where the actual address needs to be disclosed, the program requires that agency have separate procedures to keep it confidential. Excuse me. Yes, I think that's what you're asking. There's no specific procedures for that situation that you're presenting to me. So I can kind of go look at it perhaps and report back.
We may call and ask, because if you don't own any real property, then it's, if you're just a renter, then it would work pretty well. But if you actually own something and someone wanted to try to track you down that way,
well, again,
I just don't know. That's what I'm curious about is how they actually remove the name. If they own the property before they made the application, then how do you go back and pull back the name from the
I think it's best if I look into your specific question. I do know that in some situations, the agency has to collect their actual address. So Department of Tax, for example, if they own property and they own taxes and such, or the school districts, DOE, for knowing where, okay.
Yeah.
So in those situations, it is carved out as exceptions. So they can get the actual address, but they have to have separate procedures to keep them confidential.
Okay.
That's how they carve it out.
Yeah. What those procedures are. Yeah.
Okay, so I understand your specific question, which I don't have an answer.
Okay.
So I can get back to you and the committee on
Okay.
that.
Thank you. Appreciate it.
You're welcome.
Other questions before we move on? Okay, seeing none, let's go ahead and move on to the next bill, which is SB 2687. This prohibits a person from distributing or entering into an agreement with another person to distribute material deceptive media unless the media contains a disclaimer. It's focused mainly on political advertising. First up is Gary Camp for Campaign Spending Commission on Zoom. Oh, no. Brought up the executive director today. Good morning.
Good morning, Chair, Vice Chair, members. Kristen Izumi Mitao, Campaign Spending Commission. I'm here to testify that we support the intent of the bill. It's unclear, though, whether it's intended to impact campaign finance law, because the bill doesn't address campaign spending, nor does it cite to campaign spending statutes, nor its remedies. But yet it speaks about elections as well as concerns about the use of deep fake technology, artificial AI, and it requires disclaimers. So if it's this committee's intent to pass this bill, we recommend that it clarify what agency will be required to regulate this, and if it is the Campaign Spending Commission, perhaps to consider amending it to for language that's consistent with campaign spending law. And I just will highlight, it seems to affect advertising, and if that's the case, political advertising, then you probably are very much aware that campaign finance law has very specific requirements for advertising for political candidates requiring very specific disclaimers, and that's what we can speak to if this bill is to move forward. Of course, I'm available if you have any questions. Thank you.
Great, thank you. Next is Tricia Nakamatsu for Attorney General's office. Good morning.
Good morning, Chair, Vice Chair, members of the committee, Deputy Attorney General Tricia Nakamatsu, appearing on behalf of the Department of the Attorney General. We don't take any position on the intent of the bill. However, we did have a number of suggestions to improve the language in terms of consistency, clarity, particularly regarding the relevant state of mind in subsection A under subsection 2 of the bill, as well as subsection E, the definitions. We had some smaller suggestions regarding subsection B as well, but with regards to subsection C and D, we did suggest that the civil provisions all be taken out of this particular proposed section, 11 dash blank, whatever the new offense would be, and put in a different section so that you can clearly separate the civil and criminal portions of the offenses and the relief therefrom. With regards to subsection E, the proposed class of the C felony appears to be inconsistent with the intent, and so it didn't really make sense to us. Perhaps further clarification or modification is needed. I'm not sure if deletion would also be a possibility, but we just noted an inconsistency there.
Okay.
Available for questions, if any.
Thank you very much.
Thank you.
Next, let's see. Next, we have Chris Leonard, President, Hawaii Association of Broadcasters.
Morning, Chair, Vice Chair, committee members. My name is Chris Leonard, President of the Hawaii Association of Broadcasters, an organization that represents approximately 100 radio and television stations across the state. I also own and operate 6 radio stations on the Big Island. We originally submitted testimony in opposition to this bill. However, we would change our position to support with a recommended amendment. We share your concerns regarding deepfakes and AI, especially within political advertising, but we have concerns with the bill as it currently exists. Federal law requires radio and television broadcasters to accept political advertising. However, it also requires us to air these ads unaltered in what is known as the no censorship rule. Federal government exempts broadcasters from liability as a result for the content. This bill as written would create a scenario where broadcasters are required by the federal government to carry content that we are not allowed to edit or modify, while state law would hold us liable for that very same content, which puts us in a pretty tough position to be in as a federally licensed industry. We would recommend an amendment with the following carve out, as has been suggested in other states around the country. They're looking at similar bills. Proposed amendment along the lines of responsibility for including disclosures required hereunder in qualifying advertisements and communications, as well as the liability for any failure to do so would rest solely with the advertiser and the content provider and not with the broadcaster or the media platform that carries that. We greatly appreciate your efforts on this. We know that this is a significant issue. However, this would put us in conflict with federal law. So we certainly appreciate your consideration of the amendment and would be available for any questions that you may have.
Thank you very much.
Thank you.
Next, we have Alberto Lono for Surfing for Truth and Audit the Vote in opposition. Okay, so we also have Randy Pereira for Hawaii State AFL-CIO in support, Holly Plackett, Legislative Committee for League of Women Voters in support, Randy Pereira for HGEA in support, Melissa Pavlicek for Motion Picture Association with comments, and then a whole, the entire count is 5 in support, 62 opposed, and with 2 comments. That's everybody who signed up for SB 2687. Would anyone else like to testify in this measure, SB 2687? Okay. Seeing none, members' questions. Senator Bonaventura.
Chris, come on up, Chris Leonard. So recently, there was the news about George Santos in New York having this whole fake persona. So in the event he runs for election and you were given notice that there was an artificially AI created ad, And you were given notice. You are still required to broadcast it?
Especially for a federal candidate. So we're required to carry the content. This actually goes back a number of years back.
Even though you are given notice that this is a fake ad and.
Absolutely. And so it puts us in an unfortunate situation, but that's the federal law that exists. And it kind of traces its history back to very graphic abortion ads. Where TV stations said, hey, we think this is way too graphic. We don't want to carry it in the market. And federal government said, you're required to. You will not have liability for carrying that, but you are required to carry that content as long as it doesn't exceed indecency standards. But that's a whole nother liability issue that's there. So there are bills similar to this going through legislatures all across the country. And I think the intent is very good. I think we share the same concerns. There was a robocall in New Hampshire a week ago, 2 weeks ago. And, it highlights the potential problem. But I think the intent is very good. It just puts us in a very difficult situation. So the amendment that we proposed is similar to one that passed through the House in Kansas and is now in front of the Senate on that side. A number of other states have put forward numerous measures to address that, to say, yes, the content is concerning. We would have a problem carrying that, but we don't have a choice in that matter. And to be liable for something that we can't edit and we're required to accept is not a situation that we can accept, obviously.
Thank you very much.
Thank you.
Members, other questions? I do have a question for Executive Director Izumi Natao. So I think it's fair to say that you would like to have or you think it would be better if the enforcement part of it was more explicitly tied to your statute, Chapter 11, Part 13, I think is the enforcement part.
Yes, if that is the intent to cover. I mean, we noted the bill refers to Chapter 11, so it's either us or Office of Elections, and the way the content reads, it seems more applicable to our office.
Okay. So in Part 13, I can't remember, I'm sorry, I could go look it up, but is there eventually a criminal penalty in Part 13?
Yes.
If you continue to ignore the underlying rule?
Yes, it's in the 400 section.
What's it?
11-410-ish.
Do you remember if it's a misdemeanor or a felony or a petty or?
I don't know offhand. I know that all states, obviously the baseline of a misdemeanor, but of course, if that's where the committee intends to go, I would recommend that you look at Deputy Attorney General's recommendations, because of course, when we refer these for criminal prosecution, we would respect, their the language so that they can prosecute if it's referred.
Okay, all right, thank you. Other questions, members? Okay, seeing none, thanks so much.
Thank you.
We'll go ahead and move on to the next bill, which is SB 2958. This is the statutory revisions, the technical amendments bill. First up on 2958. Is John Mercy, Assistant Director for Legislative Reference Bureau. Good morning.
Good morning, Chair. The Bureau stands on its written testimony in support, and I'll be available for any questions.
Great, thank you. Next is Tom Yamachika for the Tax Foundation of Hawaii, also on Zoom.
They're unavailable on Zoom, Chair.
Okay, with comments. That's everybody who signed up on SB 2958. Does anyone else wish to testify on SB 2958? Seeing none, members, questions? Is it possible, a non-controversial bill in the Judiciary Committee? I guess it is. We'll move on to the next bill, SB 3033. That's relating to amends the criminal offense statute for tampering with physical evidence to adopt the wording of the model penal code for the same offense. First up on this is Mark Tom, Deputy Attorney General, on Zoom, or Ms. Nakamatsu. Morning again.
And good morning, Chair, Vice Chair, members of the committee, Deputy Attorney General Tricia Nakamatsu, appearing on behalf of the Department of the Attorney General. We are in strong support of this bill, and thank you for hearing it, Chair. This would basically bring our laws in up to standard, basically, with the model penal code, and make the changes necessary. We're available for questions, if any.
Okay, you can stay there. You're the only one who's signed up for this. Does anyone else wish to testify in SB 3033? Okay, seeing none, members' questions? I do have a couple for you, Ms. Nakamatsu. So, I mean, these are amendments that add model penal code language to our statute that has existed in its current form since 1972. Have there been situations that were tampering with or fabricated in this, where the current definition kept you from prosecuting somebody that you wanted to prosecute?
I believe, yes, it would help with prosecution of certain cases that have come up.
Do you have any idea why it's taken so long to notice this?
I don't know, and I don't know how often these types of offenses actually occur.
Okay, so then the amendment to paragraph 1 on the last line of page 1, I don't know if you're looking at the bill or not, adds to the criteria for the crime of making, presenting, offering, or using false physical evidence to now require that the person knew the evidence was false.
Correct.
Sounds kind of like a higher, is that a higher standard, and i.e. more restrictive, harder to prove because of the knowing?
And I'm sorry,
Okay.
Chair, this is not my area of
Okay,
specialty.
all right, no problem.
But we can definitely.
I have one further one, and there is additional language in the Hawai'i statute that is not in the model penal code. Does your office have any comments on why we should include additional language and not simply mirror the model penal code?
Oh, the additional language that's already in statute?
Well,
You mean?
there's additional language that's not in the model penal code.
I see, yes. So I believe we have had discussions about this internally within department. However, we haven't had a chance to discuss with the county prosecutors, and so we're not sure if it would have other effects that we're not aware of, but we can get back to you on that.
Okay, all right, thanks, I appreciate it. Okay, members, other questions?
Yes.
Go ahead, Senator Sanborn-Troy.
Tricia, back when you were a prosecutor, weren't there already crimes that covers tampering and falsifying evidence?
Yes.
Because I remember, because I remember there were, whenever something was amiss, I would get, as a criminal defense attorney, I would be, not me personally, but my client would be threatened with additional charges. So that's why when I read this, I thought that
I think this is,
yeah.
I'm not exactly sure which, I mean, as you know,
Yeah.
Senator, there are a number of statutes that apply just to the court process, the investigations, things. I believe this is one of the applicable charges that could be.
Okay. Well,
prosecuted.
yeah, I guess what I'm looking at is the original 710-1076 that did not add in the word or fabrication or fabricating, which to me, okay.
Good. All right, thanks. Any other
Thank you.
questions? Thank you. If there are no other questions, thank you, Ms. Nakamoto. We'll go ahead and move on to SB 3034. 3034 explicitly categorizes defenses based on intoxication that is pathological or not self-induced as affirmative defenses. First up is Michelle Pu'u, Deputy Attorney General. Good morning.
Good morning, Chair, Vice Chair, members of the committee. My name is Michelle Pu'u. I'm a Deputy Attorney General with the Criminal Justice Division. We are essentially the statewide prosecutors. We are testifying in strong support of this bill. We believe that a fair and just prosecution is tantamount to our mission as prosecutors. We believe that reclassification of these defenses as affirmative defenses will ensure that there is a thorough investigation into the legitimacy of defenses that the defendant may rely on coming upon trial. Accordingly, both sides will have an interest in preserving the evidence in question, and it will ensure that resolution of these cases will be decided upon actual evidence and not a tactical delayed disclosure of defenses. We appreciate you hearing this bill, first of all, and considering our testimony in strong support of this bill.
Thank you very much. Next is Michael Vincent, Deputy Director for Administration for Department of Law Enforcement. In support, Rebecca Leakey, Prosecuting Attorney for Hawai'i. Also in support. That's everybody who signed up on SB 3034. Does anyone else wish to testify on SB 3034? Seeing none, members, questions? I guess for the Attorney General, I did have one sort of technical question. The bill changes the phrase pathological intoxication to intoxication of the defendant that is pathological on page 1, lines 7 and 8.
Yes, sir.
Should the definition of pathological intoxication on page 2 also be changed? Because now it's it looks like there's two separate ways of describing the same condition.
Are you referring to line 20 on page 2?
I don't know. Am I referring to line 20? Yes. Okay.
That's the definition for pathological intoxication on line 20, page 2. Where it's used on the first page, that's just the term itself. On page 2, that's the definition of the term.
Okay, so you don't think there's a problem with them not being exactly the same?
No.
Okay, all right.
That's just taking the term and defining it specifically.
Okay. All right.
It's not altering its usage.
Okay, thanks very much. If there are no other questions, we'll go ahead and move on to SB 3036. This clarifies the definition of profits from prostitution to include money or property received regardless of expenditures or if it was a reimbursement or repayment of a debt. And there's some other issues, other things going on there too. First up is Albert Cook, Deputy Attorney General. Good morning.
Morning, Chair, Vice Chair, members of the committee. Deputy Attorney General Albert Cook from the Criminal Justice Division. The department supports this bill and requests that it be passed, basically to close the loophole created by the Supreme Court's majority in State versus Ibarra, where they found that the repayment of the loan in the context of sex trafficking and promoting prostitution cases cannot be the basis for profits from prostitution. So getting victims of trafficking or prostitution indebted to traffickers or pimps by buying their travel, lodging, drugs, or other items, and then making the victims engage in prostitution in an attempt to discharge the debt is a common tactic. And State versus Ibarra made it impossible for law enforcement to prosecute sex trafficking and promoting prostitution when a debt or loan was involved. So the bill closes that loophole by clarifying the definition of profits from prostitution to include repayment of a loan or debt. And the bill also moves the definitions from definitions for advances prostitution and profits from prostitution from 712, 1201, where they're kind of standalone, and moving them into the sex trafficking and promoting prostitution statutes themselves, just for clarity and for ease of use. The department urges the passage of this bill, and I'm available for questions.
Okay, great, thank you. Next up, we have Rebecca Villegas, council member for Hawai'i County? I don't remember, sorry. In support. Mike Lambert, Major Narcotics Vice Division for Honolulu Police Department, on Zoom perhaps?
They're unavailable on Zoom, Chair.
They supported as well. Next is Chris Caulfield, Executive Director for New Alliance, also in support. That's everybody I have who signed up for SB 3036. Would anyone else like to testify in SB 3036? Seeing none, members, questions? Okay, we'll go ahead and move on to SB 3037, relating to promoting pornography for minors. This allows the prosecution of persons who provide pornographic materials to undercover law enforcement officers who represent themselves as minors for purposes of undercover operations. First up on 3037 is Albert Cook again for the Attorney General. Hello again.
Morning again, Chair, Vice Chair, member of the committee. Deputy Attorney General Albert Cook from the Criminal Justice Division. The department urges passage of this bill. Currently, the promoting pornography for minors under 712, 1215 only considers the crime when somebody sends pornography to an actual minor. And the bill would allow prosecution when somebody disseminates pornography to a law enforcement officer posing as a minor. as it's a situation that we do now in our undercover operations, and it happens fairly frequently. And unfortunately, when 7/12/12/15 was passed back in 1972, that wasn't really something that was complicated. So we just asked passage of this bill. I'll be available for questions.
Thank you. Next is Michael Galoyu, Secretary Board Member for Rainbow Family 808 in support. Next is Mike Lambert, Major Narcotics Vice Division for HPD on Zoom, maybe.
They're not available on Zoom.
And they support it as well. That's everyone who signed up on SB 3037. Does anyone else wish to testify on SB 3037? Okay, seeing none. Members' questions? Seeing none, let's move on to SB 3159 relating to contested cases. Clarifies that a contested case hearing is not required when a tribunal has already issued a final decision order in a substantially similar contested case proceeding that was not appealed, or where a court of last resort has already issued a final decision on the proceedings or on other substantially similar matters. First up is Ian Hirokawa for Department of Land and Natural Resources. Good morning.
Good morning, Chair, members of the committee. Ian Hirokawa with DLNR. Department stands in support of this measure, and just want to note the purpose is to alleviate, an agency from having the burden to conduct multiple contested cases for matters or substantially similar matters that have been resolved under the criteria of this, as defined by the criteria of this measure, but also balance against the preserving due process for those who are seeking a contested case. So it's trying to seek a balance here, and I'll be available for any questions. Thank you.
Thank you. Next up is Henry Curtis, Executive Director for Life of the Land on Zoom.
They're unavailable on Zoom, Chair.
With comments. That's everybody who signed up on SB 3159. Does anyone else wish to testify on SB 3159? Seeing none, members' questions? I have some questions for Mr. Hirakawa. So if a party seeks a contested case hearing and they're denied under the terms of this bill because it's already been a similar case has recently been decided, what's their recourse? What can they do?
I would think like any other contested case now, they could seek judicial review. This doesn't prevent that, and a court would review it like any other denial.
So that's only for
hang on. I'll get to you in a second. So, how would they have standing for a review if they don't have a record? If there's no record to review, because the record from the previous contested case hearing would not be associated with that person, right?
Well, I think in the case of the land board, I'm not sure about other agencies, but in the land board, for example, if there is a request for a contested case, they have to follow up with a written request within 10 days, and a decision is brought back to the board to make a determination on whether or not the contested case should be granted. So, there is a written record, there's a staff submittal in the board decision, so there is
there is something to appeal.
Right, at least for the land. Again, I can't speak for, but with respect to the land board, yes, there is some type of record that will be there for a party.
Okay.
For the decision to deny.
Senator Moynihan, go ahead.
I'm sorry. When I'm looking at this is basically only for administrative hearings and not for court cases.
Correct. Yeah, it takes the same standard as what is in litigation, applies into administrative hearings. Yes.
I guess my question is, unlike court cases where you can actually ask for reconsideration in case something new comes along, this bill says a contested case hearing may be denied when a requesting party raises a cause of action that is identical or substantially similar to another administrative matter. I think that the problem occurs, I guess, is the substantially similar part. How do we, if we pass this, I understand the need to move on from vexatious litigants, but sometimes people especially when they represent themselves. They don't know really what they're doing until somebody tells them that it's because you didn't do this. Will they be prevented? And it sounds like they will be because it's substantially similar.
Well, it is, but I would also note that aside from being substantially similar, there's also the requirement that it already been adjudicated. So it's not just the facts, right? It's that has already been determined by a court of last resort, or a similar contested case that has not been appealed. So there's some type of resolution. I mean, as to, and like I said before, if the agency decision to deny it on any ground, really, it can be contested or appealed to a court. But yeah, as far as working or with what the individual will know or not know, I can't speak to that, what they would know. So,
okay.
Yeah.
Thank you.
Okay. Thank you.
So I had one more question. So why wouldn't, I mean, there are some differences with contested case hearings and with regular court proceedings, but why wouldn't it just be the regular rules of res judicata, collateral estoppel apply? So if the contested case hearing has already gone through the whole thing and or 80% of it, why isn't that 80% just, can't they just refer back to it and say, hey, it's already been decided 3 weeks ago, so this is what you got to deal with in terms of that part of it?
Well, I hope I'm answering your question, but I mean, I think it would apply, but I think this clarifies it in the statute because there's no statutory grounds to say that, right? This puts it in Chapter 91 to clarify, I think, similar to what you're saying, that for these matters that have already been resolved, you may not have a right to
I guess that's common law. I hadn't really thought about that in a while. Res
judicata,
collateral
yes, I
estoppel,
understand, but usually that's for court
right.
cases, right?
Chair, may I speak?
Administrative.
Sorry, who's this?
Oh,
I'm sorry. This is Russell Tsuji. I'm trying to get on video, but I'm not. I'm kind of locked out. But
he's also
if
with
I may
DLR.
add.
Oh yeah. Okay. Sure. Go ahead.
If I may explain, well, regardless of the video, I'm sorry, but if I may speak, we are added this legislation because in discussions with the Attorney General, we found out a lot of the legal concepts that apply in civil litigation have not been applied to in contested case proceedings. The courts have been reluctant to do so, and we thought perhaps with legislation to make it clear, this type of legal concepts that are already in part of our civil litigation process could be brought forward in our administrative proceeding process.
So there isn't, okay. So what you're suggesting is that in administrative law there's no analog to
use the civil law remedies or
there's
procedures, civil law procedures into the administrative law procedures.
There's no analog to saying, hey, we already decided this. You've already sued about this. You don't get to sue again. You've already asked for a contested case hearing about this. You don't get to ask for a contested case hearing.
In an administrative contested case proceeding context, yes. And so.
So, I mean, I'm sorry. Yes, you cannot.
Well, apparently there's no case law that would say you can apply these concepts like res judicata, collateral estoppel in the context of an administrative law proceeding or a contested case proceeding. On top of that, when we're drafting this legislation, we work closely with the Attorney General's office, and we put in a finding requirement, meaning the board must make specific findings and refer to the prior case that it claims that is substantial or similar or identical in order to, if it's going to deny a contested case. So there'll be a record of pointing to the record.
All right, thanks. Thank you for that additional information. Other questions?
Thank you, sir.
Okay, we'll go ahead and thank you.
Thank you.
Move on to the last bill, which is SB 3350. This requires judges, justices, and nominees for judicial vacancies to file certain disclosures with State Ethics Commission. Requires the Commission on Salaries to consider the deterrence of bribery and corruption when making its salary recommendations. First up is Thomas Berger, staff attorney for the judiciary. Good morning.
Good morning, Chair, Vice Chair, members of the committee. Thomas Berger, staff attorney. The judiciary opposes just one portion of the bill, page 3, line 12, where it references justices and judges. So justices and judges are already required under Rule 15 of the Rules of the Supreme Court to file annual financial disclosure statements. So in that way, the bill is not necessary. And when you compare what the state ethics code requires, that would be section 84-17F in terms of disclosures for state employees. The judges have very similar and in some cases identical requirements for their annual financial disclosure statements. Those statements are public record, and I'm available to answer any questions.
Okay, thank you. Next up, we have Robert Harris, Executive Director for the Hawaii State Ethics Commission. Excuse me. Morning.
Good morning. Aloha, Chair, Vice Chair, members of the committee. The State Ethics Commission has not yet had an opportunity to review this bill. We hope that they will consider it at the next Sunshine meeting next week, Wednesday. We do offer, staff offer comments, which include first, that as a result of the ethics scandals on a national level involving the Supreme Court, our Ethics Commission has engaged the judiciary in a broad discussion of standards, which would include potentially the disclosure of things like gifts, financial disclosures, et cetera, and sort of the current mechanisms that are there. Judiciary has been very open and collegial about those conversations, and this might be part of that conversation moving forward. Second, if this bill were to move forward, we can operationalize it without any significant change in staffing or budget requirements. Thank you for the opportunity to testify.
Thank you. Next up is Judith Mills Wong for League of Women Voters with comments. That's everybody who signed up for SB 3350. Does anyone else wish to testify in SB 3350? Seeing none, members' questions?
Yes.
Senator Sembwen Matura.
So, I don't know, judiciary, I guess, come on up, since this is sort of a comment or a question, and it's similar to what Senator Owa said in prior hearings, that when you apply to be a judge, you should also consider it to be public service. And if a salary makes you vulnerable to bribery and corruption, it seems to me it's a character flaw rather than a salary commission issue. So shouldn't this bill be amended to say that instead of salary recommendations, that the Judicial Selection Committee should consider all income and debt of a prospective nominee to see whether or not they are prone to be bribed or corrupted?
If I understand your question correctly, so you're referring to page 3, line 17.
And page 6.
Page 6, okay. So the judiciary actually has no position on that, so I would defer to the senator in terms of what would be best.
Okay.
Other questions?
Yeah, I guess it would be Robert Harris.
Okay, thanks.
Okay, same question. I mean, shouldn't this bill be actually be amended, that instead of salary recommendations, that it should be the Judicial Selection Committee to determine the nominee's character and their propensity for accepting bribes and corruption, knowing what the salary is?
So as I said before, the Ethics Commission hasn't considered this bill, so I can't speak on behalf of the Ethics Commission. It's just a general observation. I do believe that's squarely a policy decision for you guys to decide. I think you could potentially do both if that's something you wanted to do as well. And just as a general observation, I am aware of other federal level where they do consider salary as a means to address the potential for corruption. I agree with you, it's still a character issue. However, at least at the federal level, there is some consideration of trying to make sure agents are paid well enough, for example, that they are less susceptible to looking at bribes or other things. Again, it's a policy decision, and I welcome the discussion and debate.
Okay, thank you.
Thank
I mean, they know the salary coming in. Thank you.
Mr. Harris, if you don't mind, so following up on that, so, I mean, I guess, I don't think we're anywhere close to this at this point, but say we decided we're gonna pay judges $20,000 a year. Doesn't that kind of encourage, doesn't that raise a whole host of issues of they need the money to survive in Hawaii? And wouldn't that make being corrupt more, what's the word I'm looking for? Tempting, I guess. Yes, a good person wouldn't, and they would know what and they know what they were getting into, but it seems like it's just asking for trouble.
I had the opportunity to travel to a country called Moldova, which is the poorest country in Europe, as a part of a federal exchange program where they deal with rampant bribery due to years of systemically not paying government officials very much at all. And so it's become such a part of the culture to offer bribes that now they've actually enacted laws where they have hundreds of auditors that review every single employee's financial records, including their families, just to be able to observe any illegal transactions. That's solely their focus on the corruption level. And again, they blame that fundamentally on decades of underpayment, such that oligarchs coming in from Russia know, and it should become a normal part of the transaction, that you will offer money as a way to get your building permit, whatever type of transaction through. So plainly, there is a link between salary and the levels of corruption. I also fully agree with the senator's observations. It's also a character issue. However, it can become cultural over time as well.
What about the flip side of it? Countries that are known for not having corruption, do they pay government officials a lot? Do you know?
I suspect nobody has been able to say that there's a direct correlation to that, but probably that is a factor, as well as many other factors, which would include, I think, a robust character analysis. It would include a robust system of checks and balances to make sure that those examples of corruption are caught and weeded out. So again, I do believe it is a comprehensive approach. This is probably one of the factors, however.
Okay, all right. Thank you very much. Other questions, members?
Yes, just follow up. Sorry. I mean, the reality is we're not in Moldova, and every time the judiciary comes in with a budget request, they are asking for reasonable salaries so that they are able to recruit. Knowing there is already, all I'm saying is that there's already an incentive for reasonable salaries built into our system, unlike Moldova, correct? I mean, basically, we can't fill the judges, the vacancies, if we don't offer enough. Don't you agree?
I do believe that there is a rational reason to offer a competitive salary. I think there have been points in time where people have argued that the salaries have not been high enough compared to the private sector, and that there has been pressure then to raise accordingly salaries as well. So I agree that we are not Moldova, fortunately, and our salaries are greater in that regard. However, I wouldn't say, generally speaking, that it's not an issue at all to be aware of.
Okay, thank you very much.
Thank you.
Members, other questions? Okay, if not, I think I'm ready to make some recommendations if you guys are set to go. Okay. Let's go back to the top of the agenda, SB 2686, relating to disclosure of personal information of certain public servants. Well, I say I'm ready to make recommendations, and this one I'm not. So I'm going to defer it until February 27 at 9:31 a.m. What day is that? Thursday? No. 27th. Tuesday the 27th at 9:31 a.m. in this room, 016. And we'll try to grapple with some of the thorny issues involved there. Next up is SB 2687, prohibits a person from distributing or entering into an agreement with another person to distribute materially deceptive media unless the media contains a disclaimer. This is another one that I think is a work in progress, but I would like to go ahead and move something along, and we'll talk about it some more. So the recommendation would be to exempt the broadcasters from liability where federal statute or rule requires them to run ads without editing them, and we'll apply the apply the bill to political advertisements only per the CSC's comments. It's not exactly what you asked for, but we'll just restrict it to advertisements, which is a defined term. And then we'll specifically mention the CSC as an agency that can enforce on page 5 and lists several, and authorize the CSC to utilize the enforcement provisions in Chapter 11, Part 13. Note in the CR that the committee intends that the CSC to be able to refer for prosecution any violations of this new crime under 11-411. Per the Attorney General, we'll use the knowing state of mind for the elements of the offense on page 2, and I'll put a bad date on it because I don't know if that's, not sure this we'll see what the next committee does if they hear it, but let's put a bad date of April 14, 2112. Questions, concerns? If not, Vice Chair.
Chair's recommendation is to pass SB 2687 with amendments. Chair Rhodes.
Aye.
Vice Chair Woods, aye. Senator Elefante.
Aye.
Senator San Buenaventura.
Aye.
Senator Owa.
No.
Measure passes.
Thanks. Next up is SB 2958. This is the statutory revision technical amendments bill that we generally pass every year. Recommendation here is to pass as is. Questions or concerns? If not, Vice Chair.
Recommendation is to pass SB 2958 as is. Of the members present, are there any no votes or reservations? Hearing none, the measure passes.
Thank you. Next up is SB 3033. This amends the criminal offense statute for tampering with physical evidence to adopt the wording of the model penal code for the same offense. The class of offenses remains the same. Recommendation here is pass as is. No text on this one? Pass as is. Questions or concerns? If not, Vice Chair.
Chair's recommendation is to pass SB 3033 unamended. Of the members present, any no votes or reservations? Hearing none, the measure passes.
Thank you. Next up is SB 3034, explicitly categorizes defenses based on intoxication that is pathological or not self-induced as affirmative defenses. Again, our recommendation is to pass as is. Questions or concerns? If not, Vice Chair.
Chair's recommendation is to pass SB 3034 as is. Of the members present, any no votes or reservations? Hearing none, the measure passes.
Thank you, members. Next up is SB 3036, relating to offenses against public health and morals, clarifies the definition of profits from prostitution to include money or property received regardless of expenditure or if it was a reimbursement or repayment of a debt. Recommendation here is to pass with technical amendments only. Questions or concerns? If not, Senator Gabbard.
Recommendation is to pass SB 3036 with amendments. Members present, and are there any no votes or reservations? Hearing none, the measure passes.
Thank you. Next up is SB 3037. This allows the prosecution of persons who provide pornographic materials to undercover law enforcement officers who represent themselves as minors for purposes of undercover operations. Again, recommendations to pass with text only. Questions or concerns? If not, Vice Chair.
The recommendation is to pass SB 3037 with amendments. To the members present, any no votes or reservations? Hearing none, the measure passes.
Okay, on SB, thank you. On SB 3159, this clarifies that contested case hearing is not required when a tribunal has already issued a final decision and order on a substantially similar contested case proceeding. On this one, I think I'm not quite ready to make a recommendation, so let's go ahead and put this one off till Tuesday the 27th at 9:31 in this room 016 as well. And moving on to SB 3350, same situation. I'm sorry, this requires judges and justices and nominees for judicial vacancies to file certain disclosures with the State Ethics Commission. And the previous one was relating to contested cases. Again, I don't think we're quite ready on this, so I'm going to defer this until February 27 on Tuesday at 9:31 a.m. at 016. That's it. Thanks for being here. We're adjourned.